You know, maybe Jimmy Carter actually had it right when he said that he sends important correspondence via snail mail. Turns out a New York judge is defending a controversial ruling that gave the government access to an entire email account linked to a person who may have been tied to a money laundering scheme. Now, the Southern District Magistrate, Judge Gabriel Gorenstein, says that email accounts are similar to hard drive, which can be seized in their entirety by law enforcement acting with a warrant and then held for the inspection of the entire contents during the pendency of investigative and prosecution. Doug, tell the public why this matters.
Why this matters? Well, if you look at this case with a case we discussed a while ago about them seizing your phone and just kind of looking at your phone, the law is trying now to figure out where it's okay for a police officer to act or law enforcement using their own judgment. And that's where we're going to have a problem. So now, the last time we were talking about it, we were saying phones without a warrant. Now we're talking about them getting a warrant, but how far that warrant goes. So this is where why it's important for the public. It's discretion. It's discretion we're giving to law enforcement to make decisions on what they can and can't do to the public.
So let's say somebody's investigating whether or not you were involved in a money laundering thing, and then all of a sudden they take your whole hard drive and they find out you had correspondence with somebody in a completely unrelated crime, like covering up for a hit and run or something else. Theoretically, they can use what they found and prosecute you on something completely different that they never intended the warrant for in the first place, right?
That's exactly what this judge is saying. They're talking about plain sight. They're saying this is stuff that you're allowed to be looking at, and if you're allowed to be looking at it and it's criminally related, you're allowed to use it in prosecution.
We all know everybody now puts their whole life online. That's here. Right. So you open it up, you're basically opening up everything. Now, when it comes to email, privacy or lack thereof, inmates are also not off limits. Now, I want you to take the case of the former Pennsylvania State Senator Vincent Fumo. Fumo convicted back in 2009. You may remember this case, guys. Unbelievable. Guys say the authorities he defrauded the state and two nonprofit organizations out of $3.5 million. He got in more trouble with the law following his conviction. Well, in 2011, prosecutors seized a whole bunch of angry emails he sent from prison. In the emails, Fumo lashed out at the jury that convicted him and the prosecutors, who then said he should be resentenced. And if you saw the Times piece today, it speaks to how inmates' prison phone calls to or from lawyers go unmonitored. However, federal prosecutors, the feds, they begun reading prisoners' emails to attorneys, which Times says is a practice wholly embraced in Kings County and Brooklyn, where prosecutors have said they intend to read such emails in almost every single case. So I think everybody got it, that if you ran your mouth in jail, you spoke to another inmate or whatever, they could flip on you and, okay. Right. But as we saw with even certain mob guys here, now you can't even talk to your attorney without that also being, part of the record, if you will. That's different than it used to be, right?
It is, and it's astounding. You create a medium through which we can speak to our clients, not have to run to the jail, sit there for 2 hours in order to get in, to have an attorney-client relationship. You create that medium through which we can have those conversations, and then you tell us.
It's just really clear, Jimmy. If I'm your client and I tell you something as my attorney, we have a privileged conversation. Now all of a sudden, because of the setting, if I say it in prison, now that's all of a sudden different. It didn't used to be that way, right?
No, it's a private conversation. Look, if you and I are lawyer and client and we say things in front of other people, there's no privilege. This is a privileged communication via email. And there are split decisions here. Judge Irizarry in Brooklyn said, oh, no way. Because what this issue really is about is they're allowed to read those emails between the inmate and other people. They might be trying to commit other crimes, destruction of evidence, obstruction of justice. That's fine. But somehow prosecutors are saying that we can't distinguish between when they're talking to their lawyer and talking to their friends. And Judge Irizarry said that's ridiculous.
Well, it should be, because there's an attorney and there's everybody else.
It's very, very simple. It's unfair. It's ridiculous.
And I would imagine, right, that it kind of throws a whole monkey wrench in the process. How do you put together a case if you guys sitting behind bars, right?
We talk a lot about patriotism in our country, and we have a great Constitution. The First Amendment is basically eroded, and what's happening is the Sixth Amendment, your right to counsel, is eroded at the same time. And the fact that you have federal prosecutors listening to your conversations that are meant only for your attorney, is unconscionable. It's a clear violation of the Sixth Amendment. The fact that they're going to take letters that you actually write to your attorney from prison, and again, this is from prison. These are not people who have the liberty to come to meet us in our offices, is unconscionable. And what I found in Westchester County is that they are now offering video conferencing, which I refuse to use because there's no expectation that that's not going to be used also. So that eventually one day you'll be speaking to your client and the video of that conversation gets played in front of a jury. And even if it doesn't get played in front of a jury, the prosecution has the benefit of having information, and they decide what it means. So I've had federal prosecutors tell me, this is when your client said, Fluffy, he's not talking about the dog, he's talking about, you know, yeah.
For
Is
me,
he talking
Dougie,
about the
we
dog?
got about 30 seconds. So much stuff is relating around the new technology, communication, what is and isn't off limits. I just have a feeling the public's going to look back 5-10 years from now and said, whoa, I didn't sign up for this.
Yeah, well, I mean, this is where everything is now, and where you're trying to take old law, old cases, and you're trying to relate them to new technology. It's very difficult to do.
But we are signing up for it too, because when you click I agree, you have signed up for it.
Whether you mean to or not.
Yeah.
All right, gentlemen, thank you very much. All the time we have for tonight. I'll see you back here at 6 p.m. We'll see these guys here next week at Wednesday nights as always. Till then.